Hey, so I got a good chunk of time left, so I'm just gonna try to start from the beginning now and get to where I just left off, coming from the back. So, all right, first question. Explain the ESA's jeopardy and consultation provisions, Section 7. Why are these provisions so significant to understanding decision making pertaining to federal public lands? Please use an example in your answer. So, Section 7A1 establishes establishes the affirmative duties that federal agencies shall take to do more than just avoiding causing more harm. Section 7A2 requires agencies to ensure, this is the jeopardy provision, ensure that the action they authorize, fund, or carry out is not likely to cause jeopardy or not likely to jeopardize the continued existence of a species or result in the destruction or adverse modification of a habitat of such species. And then this also then, that Section 7 also requires consultation. There's that consultation provision, which requires the action agency, which I do have a slide for this somewhere, requires that action agency, got to scoot here, doing a little shuffle, but requires that action agency to, conduct, carry out an activity or carrying out an activity to consult with the Fish and Wildlife Service or NOAA on how to avoid jeopardy or adverse modification to critical habitat. So I guess here, you got like this action agency. Just initially, when they're just considering the action, they're gonna give the Fish and Wildlife Service or NOAA, give them a call and ask, hey, what's the story with this area? Are there any potential listed species we need to worry about? I'm not sure if that's exactly how it goes down, but just for the general purposes here. And then, so say the agency's like, yeah, there are, you may have to consider this, that, maybe this possibly. So the action agency will then conduct a biological assessment to just determine if, okay, maybe there's some listed species in the area. Is this action we are pursuing, is this going to affect them? And then, if that biological assessment conducted by the action agencies themselves determines that it's going, okay, yeah, this action is going to affect these listed species, then they got to consult with the Fish and Wildlife Service or NOAA, and this is like the informal, what's it called? Informal consultation. So then they got to, after the informal consultation, then they formally consult with the Fish and Wildlife Service, and those agencies, those governing agencies, administering agencies, are going to conduct a biological opinion. And the biological opinion essentially decides whether the action is likely to jeopardize continued existence of the listed species or result in adverse modification or destruction of habitat. So there's kind of three routes that they go from the biological opinion. Let's see. I guess I'll just go here. So if the biological opinion does find that the action is going to likely cause jeopardy or result in adverse modification, the administering agency might suggest some reasonable and prudent alternatives to avoid jeopardizing that existence or avoid the destruction or modification of habitat. Then additionally, maybe they'll conduct it. Maybe if the action may result in an incidental taking, so it's not going to jeopardize the existence of the species. It's not going to destroy or adversely modify habitat. But there's a chance it might, a couple might get caught in the crossfire. A couple listed species might get caught, might get killed. So the Fish and Wildlife Service can issue these incidental take statements, which removes that liability. With that biological opinion. So that'll allow them to continue forward with their action as is with their incidental take statements. I do think those incidental take statements, like I have here, they do come with some stipulations. So I shouldn't have just said that they can go at business as usual. But it's just these incidental take statements. There's some things that it concludes that the listed of a taking of a listed species incidental to the agency incidental to the agency action will not violate 7A2. So it's not going to jeopardize or adversely modify habitat, and it just the statement will just specify the impact of the incidental take, specifies reasonable and prudent or prudent measures to minimize the impact, and sets forth some terms and conditions that must be complied with by action agency to implement measures in 1 and 2. So it might just have a few stipulations in there. And then, there's the third option, which is just a full stop on agency action. And this will, because maybe this action will result in destruction of habitat, jeopardy. And this, because the fish and FWS and NOAA can't halt an agency action. This occurs in the courtroom, as we saw in, as I've mentioned in the TVA versus Hill. So maybe they, FWS, NOAA, they conduct their biological opinion, and they do find it's going to jeopardize continued existence. They issue this biological opinion with that, with those RPAs, and maybe the agency ignores that, and they decide to go ahead with their plan. Then someone steps in and litigates them, and they're completely enjoined and halted in their progress. I think, honestly, I don't even know if that was what this question was asking. But I like going through these flow charts that I make. Yeah, I mean, I have TVA versus Hill. Okay. Yeah, okay, I'll just move on. So, what is a biological opinion in the context of the ESA? Describe a real or hypothetical example of how a biological opinion, or BIOP, or BIO, or BO, could impact a proposal or decision by the U.S. Forest Service, Bureau of Land Management, or National Park Service. Be sure to reference an incidental take statement and permit and reasonable and prudent alternatives somewhere in your response. So, like I said, this is part of those Section 7 procedural consultation requirements, as I kind of just walked through here with the flow chart. But a biological opinion, essentially, that action agency conducts their biological assessment. They find it might, their action could affect listed species, so then they therefore go on to the formal consultation with the administering agency, and the administering agency then conducts this biological opinion. And essentially, the biological opinion decides whether the action is likely to jeopardize the continued existence of the species or result in adverse modifications and destruction of critical habitat. If so, the secretary, along with his biological opinion, is going to suggest some RPAs to avoid and mitigate and minimize those adverse effects of the action on those listed species. If it is found that the action is mitigated by the RPA, so maybe they do recommend the RPAs, so they might do the BO, they might give the BO and the RPAs, and then also an incidental take statement. So anyway, if it is found that the action as mitigated by RPAs will cause not jeopardy, but may result in the take of a listed species, then the administering agencies can issue an incidental take statement. So like I said, it's not going to jeopardize the species, it's not going to adversely destroy the habitat, but a few might get caught in the crossfire, and they're going to give out that incidental take statement. And like I said, those administering agencies, FWS and NOAA, they can't halt agency action despite in favor of issuance of an unfavorable BO, but that does they give out that unfavorable BO, and the agency still continues forward with that action, then they're going to be open to litigation, and then they're also very liable to being found as arbitrary and capricious in their decision to go forward with that action. And the RPA, so essentially those are reasonable and prudent alternatives, and these are just mitigation measures to minimize and avoid jeopardy or adverse modification of habitat. And let's see, what else did I need here for this one? So let's see, where am I at? Okay, so I guess an example of an issuing of finding of this BO and issuing of RPAs and incidental take statements. So there's the Southwest Center for Biological Diversity versus the Bureau of Reclamation. So anyways, Bureau of Reclamation, they manage Lake Mead, the dam. I think it's the Hoover Dam. I still didn't look that up, but essentially, they do a biological assessment on the potential effects. That they're doing some work, activities in the lower Colorado River. So I think they're probably letting different volumes of water through. The lake levels are rising and falling, and this is having, they do a biological assessment to see is this affecting that endangered flycatcher that relies on those riparian areas along the lake and the lower Colorado? How is that our activities affecting that? They do find that it is having an effect on those flycatcher, so they can do a formal consultation with the Fish and Wildlife Service, who conducts a biological opinion, and they do find that their actions, in that Lake Mead, those Lake Mead and Lower Colorado actions, are going to jeopardize flycatchers. So they propose some reasonable and prudent alternatives, and so this essentially, in these RPAs, it requires that the Bureau of Reclamation to procure and protect 1,400 acres of currently unprotected riparian habitat. With there's no specifics provided with that, no specific or suitable areas identified, and no mandate that the habitat needs to be established before potential destruction of the habitat around the lake or in the lower Colorado. And the only real stipulations that come with that RPA are that 500 acres of that procured and protected habitat needs to be in place by January 1st, 1999, and the remaining 900 acres need to be in place by January 1st, 2001. And then there's also a provision that there needs to be an initiation of a necessary ecological restoration and or reforestation as well for that flycatcher habitat. And then there's some additional on and off-site compensation for historical flycatcher habitat that's been lost, as well as some continued development for a multi-species conservation program. And then additionally, with these the BO and the RPAs, the Fish and Wildlife Service also issued an incidental take statement to the Bureau of Reclamation, and in that statement there was a permitted an unquantifiable take of flycatcher at the Lake Mead Delta, and essentially I think what it was as that, because there was a lot of that riparian flycatcher habitat on the banks of Lake Mead, but as that water level, I think it was going up, was the action, the lake level was rising, and therefore it was going to kill off all those willows, because it was going to rise to a point where those willows were going to be inundated for longer than they could sustain, and those willows were going to die off, and the habitat was going to be destroyed, adversely modified, as well as they issued that incidental take statement, because as those trees die and fall, there's definitely going to be flycatcher nests in those trees that are falling, and then flycatcher are being killed. So that, I think that's where that unquantifiable incidental take statement comes from as well in there. And it was I think because originally, in the case, there was the first set of RPAs were a bit more substantial, and there was more specifics, and they were definitely a bit harder hitting. But then, the Bureau of Reclamation came back and stated that they don't have a ton of control over the lake level. It's more that is dependent on upstream precipitation and effects. So this was kind of the second round of RPAs. But essentially, that's an example of how that process went. You had the action, the Bureau of Reclamation, conducting their biological assessment of flycatcher, and then finding that So then you get to here with the Fish and Wildlife Service finding that it's going to jeopardize the flycatcher, so they come back with some RPAs, and then they also issue an incidental take statement. So that's kind of a walkthrough of that, an example of how that works. What is the primary difference between listing and managing a species as endangered and threatened pursuant to the ESA? Be sure to discuss the issue of management flexibility in your response. I should have put a little something on here about management flexibility. But essentially, so you have an endangered species, which is any species which is in danger of extinction throughout all or a significant portion of its range. And then you got your threatened species, which is any species which is likely to become an endangered species within the foreseeable future throughout all or a significant portion of its range. So it's definitely there's the big difference there in the statute. Let's see, what else do I got in here written? And so a big thing is so going back to that Section 9 prohibition of take, in the statute that only applies to endangered species. There is So essentially, yeah, endangered species do come with that Section 9 prohibition. Whereas the threatened species, they don't come with that Section 9 prohibition. However, there is the Section 4D, in which the Secretary can extend that Section 9 prohibition to threatened species. So, so yeah, definitely, that I mean, I think that's probably the management on the management side of things. Those endangered species come with that Section 9 prohibition versus threatened, which doesn't. So you're having to, there's definitely a much more management consideration for those endangered species if they're present and you're conducting actions on land. You're gonna be a lot more limited in what you can do. You're gonna probably have to go through you're gonna have those reasonable and prudent alternatives to consider and to minimize and mitigate those impacts to those endangered species. Explain the ESA's take provision and how it relates to harm, and thus land use and/or water management. Be sure to discuss the ESA and ESA regulations pertaining to take in your response. Provide an example of an indirect take in your answer. This is one I gotta it's not too crazy or anything, but it's just there's some moving parts. All right, so there's the take provision, which is essentially that Section 9, not just limited to federal actors, but any person who is. Do I have a slide for this? I don't think I do, but for some reason, maybe not. No, wait, no. Yeah, okay. All right, that's kind of a slide, not really. But Section 9, so yeah, not limited to federal actors, and any person is prohibited from taking an endangered species. And this is direct or indirect. Direct with specific intent not required, and can be extended to threatened species by the Secretary via Section 4D. And then, so take, as described in statute, is to harass, harm, pursue, hunt, shoot, wound, kill, trap, capture, or collect, or attempt to engage in any such conduct. So yeah, direct take then is just essentially reducing wildlife to a possession by capturing or killing it. And then harm, and thus land use and water management, okay. And how it relates to harm. So harm, that extends to indirect take, and we saw this in the Palila versus Hawaii Department of Natural Resources case, where essentially, Hawaii introduces these. I'm saying Hawaii wrong. Hawaii. I don't want to mispronounce it, but anyway. So Palila versus Hawaii Department of Natural Resources introduces these feral goats for sport hunting. I think it's on some wildlife management area, state area. Anyway, but as they introduce these goats to for recreation. These goats go about and they eat these mamane seedlings and shoots, and which the endangered Palila bird requires mature mamane trees for for shelter and for food. So they don't the eating of the seedlings is not directly impacting the Palila birds. However, but it is by eating those seedlings and saplings, they're removing potential for them to grow to maturity, and therefore it's bringing harm to the future Palila that could inhabit those potential trees for food and shelter. So the courts side with this case with the Palila or Sierra Club, and they state that the Mamane forest is essential for the Palila's survival. The bird has evolved in the Mamane ecosystem for over the centuries and is uniquely adapted to feeding upon Mamane. The Mamane trees provide food, shelter, and nest sites for the Palila. So essentially in this case, you see the extension of harm to that indirect taking by the damaging of potential future habitat. And then following this case, the endangered or FWS actually promulgates a new regulation to define harm, in defining harm in the definition of take. And that new definition is just essentially an act that kills, injures wildlife. Such an act may include significant habitat modification or degradation where it actually kills or injured wildlife by significantly impairing essential behavioral patterns, including breeding, feeding, or sheltering. So essentially, that section take extends to land. Now then there's that Babbitt versus Sweet Home Babbitt versus Sweet Home Oregon case where it was I have to reread that case, but essentially it's extends to habitat modification that could affect future that species in the future. So it definitely it places definitely more restraint on management of lands when you have to consider potential future members of that listed species as well. What is the best available science mandate of the ESA? So essentially, the best available science mandate it just requires that the secretary solely consider the best available science when designating a species as endangered, and that's it. Yeah, unlike the post the 1978 amendment for the critical habitat designation, which we talked about earlier, the species listing mandate is solely on best available science, not that cost benefit analysis or other factors of the area. So Congress essentially in this is just directing that the listing be fundamentally science based. What ESA provision permits the U.S. Fish and Wildlife Service to delist grizzly bears in the greater Yellowstone ecosystem while keeping the species listed as threatened in the Northern Continental Divide ecosystem? So I do have a slide for this one. This is kind of why I wanted to do this, because I made a bunch of slides for it. Here we go. So there's the distinct population segments. So, these are groups of the same species that occupy geographically separate areas. And in the statute, the ESA describes species to include subspecies, and for vertebrates, distinct population segments that interbreed. So only for vertebrates, this distinct population segments extends to classification. But essentially, so it gives flexibility to provide different levels of protection to less than a whole species. So essentially, you got your DPS of the Northern Continental Divide grizzly bears up here. You got Eureka and Kalispell and whitefish and stuff. So you got your Northern Continental Divide distinct population segment here, and then you down here in Yellowstone, you got your greater Yellowstone ecosystem grizzly distinct population segment here. So with that distinct population segment, listing option, that allows them to consider potentially delisting this distinct population segment here while retaining this DPS as listed up here. It gives more flexibility to the management of these species. Describe a real or hypothetical example of how a decision. This is also very crude. But it's pretty simple to get the point across. Describe a real or hypothetical example of how a decision to list or not list a species pursuant to the ESA could be challenged in court using the Administrative Procedure Act. Be sure to sufficiently explain the best available science mandate and the arbitrary and capricious clauses of the ESA and APA in your response. So for this one, I threw it back to first test and the northern spotted owl versus Hodel case. Essentially, so we got the Fish and Wildlife Service has petitioned to review the status of the northern spotted owl as potential for listing as endangered or threatened. So the Fish and Wildlife Service initiates the status review of the northern spotted owl. They assemble this team of biologists, including a Dr. Mark Schaefer, and I guess to me this is where I consider they're definitely bringing together this. I would consider this team of biologists and Dr. Mark Schaefer as that best available science. And this, the best available science, i.e., Dr. Mark Schaefer and the biologists come to the conclusion that continued harvesting of the old growth in this Pacific Northwest here is likely to lead to the extinction of the subspecies in the foreseeable future, which argues strongly for listing of the subspecies as threatened or endangered at this time. So they come out and they're like, if things continue as they are, this species is going to be needed to be listed. The Fish and Wildlife Service then has the report peer reviewed by population viability experts, who concur. They concur with the analysis and they come to the same conclusion as well. The Forest Service, Fish and Wildlife Service, completes the status review and they announce their decision that the ESA listing for the northern spotted owl is not warranted at this time. This decision is then reviewed and was litigated and reviewed in court under the APA arbitrary and capricious standard, and the agency action is arbitrary and capricious. An agency action is ruled arbitrary and capricious when it's when that agency doesn't provide a rational connection between the facts found and the decision made, or they potentially overlooked an important aspect of the issue at hand, as well as I keep forgetting that. But anyways, they don't make that there's not a rational connection between that decision made and the facts found. And in this case, the decision made was not to list, and the facts found were by the Dr. Mark Schaefer, the biologist, and then the peer reviewing scientists as well. So the best available science. And so the Fish and Wildlife Service provides no rational connection between the facts found by the biologist and the decision not to list the species. They ignore the best available science, and then in turn are declared arbitrary and capricious and remanded in their decision. So that best available science provision essentially is listings that are solely based on the best available science. It's best available scientific and commercial data available. Strictly a scientific decision is the listing of species, not an economic cost-benefit analysis or anything like that. And in this case, the Fish and Wildlife Service brought in a team of scientists, biologists, Dr. Mark Schaefer, to use the best available science in this listing decision, and they went against it without providing any evidence as to how they made their decision. And then, the arbitrary and capricious standard of the APA, it's that hold unlawful and set aside agency action findings and conclusions found to be arbitrary, capricious, and an abuse of discretion or otherwise not in accordance with the law. It's a narrow scope of review. The court's not to substitute its judgment for that of the agency, but the agency must examine the relevant data and articulate a satisfactory explanation for its action, including a rational connection between the facts found and the decision made. So there's that call for a rational connection in that arbitrary and capricious standard. And now I'm back to where I just left off earlier, so I'm wrapped up. Yeah, I guess that'll pretty much do it for me. Yeah, I guess I'll just, thanks.